Hello everyone. In the following 3 minutes I will try to give you a general glance regarding to what Mexican contract law states with respect to a breach of contract derived from a pandemic situation. So bear with me 3 minutes and hopefully you will obtain enough knowledge to make an informed decision if any of your Mexican business partners fail to deliver. First things first, this will only be applicable if you have a written agreement that clearly states that the governing law will be Mexican, or if you don't have a written agreement and your counterparty has its commercial domicile in Mexico. So basically, there are two concepts that you want to have in mind: force majeure and the doctrine of unforeseen circumstances. Fortunately, both concepts are widely used in all jurisdictions, so I will focus on how those concepts have been applied in Mexican courts. Force majeure is an event or effect that can be neither anticipated nor controlled. This is pretty much the Black's Law dictionary definition, but applies also perfectly to Mexican concept. In Mexico, force majeure constitutes an exception of liability. This is applicable both for civil and commercial transactions. This exception will not be available to the party in breach if such party contributed or caused the event, or if such party accepted the risk, or if said event risk is imposed to said party by law. So please go on and review your contracts. If it does not contain any clause specifically addressing force majeure, the rules I just mentioned should be applicable. But if you see that there is in fact such clause and allocates the risk differently to what I just explained, then such wording shall prevail to what law imposes. A test for reviewing if an actual event considered as force majeure is available neither in law nor in case law, and therefore case-by-case analysis must be made. COVID-19 pandemic event is for sure an event of impossible anticipation, but by itself it does not necessarily constitute a force majeure event. Nevertheless, its consequences might be very well considered as force majeure events. Let's say governmental binding restriction to have more than 10 workers in the same site in order to avoid COVID-19 spread may be a force majeure event for a construction that will not meet a specific milestone or event or even the deadline at all. Force majeure is used as an exception of liability if the payment or delivery is actually possible, regardless of its cost. This means that the evidence in trial will be focused on if the compliance with the agreement was in fact legally impossible, not if it was grossly costly or difficult.